Okay, Comsec.
Yes, sir. Good morning. Good afternoon. Yes, sir. Good afternoon.
Okay, the meeting of justice is now resumed. Next to present is the PAO, Public Attorney's Honorable Acosta.
Okay. With the permission of the Honorable Chairman, Justice Vicente Veloso. Pwede po ba akong magtagalog para maintindihan po ng maralitang Pilipino? Justice?
Mas maganda, wag lang masyadong malalim at Bisaya kami.
Opo, sir. Para po maintindihan ng lahat ang history, ang PAO po ay may malaking kaugnayan sa pagkawala ng death penalty noong June 2006. Sa panahon po ni ERAP, 7 po ang nabitay, isa dyan si Exagaray, si Leo. Pagpasok po ng panahon ni President Gloria Macapagal Arroyo, ang bibitayin po ay mahigit 1,000. Hanggang sa nakipag-ugnayan sa akin ang simbahan sa pamamagitan ni Monsignor Bobby Ulaguer ng NBP na may bibitaying 2, si Roberto Lara at Roderick Licayan. Ang sabi po ni Father ay inosente itong 2 sapagkat may 7 pang at large at sila ay may kasong kidnapping with ransom. So pinag-aralan po namin ang kaso at nakakuha kami ng 2 testigo na nagsasabing inosente sila. Punta po ako ng Supreme Court, nag-argue ako noong January 26, 2004 at nag-grant po ng Supreme Court after my 4 hours na oral argument ang suspension of executions. At ako po ay nag-ibang bayan sa tulong ng UN. Nakarating ako ng India at na saan-saan para lang po ako magtago dahil hindi ko po alam sinong kalabang ko sa mga kasong ito. So ang punto doon ay after 1 year and a half, pinag-aralan po ninyo sa Kongreso ng aming mga mahal na congressman at senador. Kaya po sinuspend na nyo ang lahat ng death penalty at nababa sa habang buhay o reclusion perpetua or life imprisonment. Ngayon, sa paglipas po ng panahon ay narito na po ngayon ang panukala ninyo na ibalik uli ang death penalty. Masakit po sa dibdib ko na mabalik ito, pero sa akin pong pag-aaral ng mga jurisprudence sa pamamagitan ni Justice Isagani Cruz, ni Professor Father Bernas, lumilitaw po na tamang-tama talaga ang pahayag ng ating chairman Vicente Veloso tungkol sa supremacy of the Constitution. The Constitution must ever remain supreme, ayon po kay Justice Cruz. At ito ang basic and paramount law to which all other laws must conform and to which all persons, including the highest officials of the land, must defer. Sinabi po all laws, hindi po sinabing except international law. At doon po sa Article 2 of the Constitution, tama po sinabi doon, i-adapt natin ang international law. Pero nagturo po ako sa ilalim ng deanship ni Dean Rufus Rodriguez ng statutory construction. Wala po tayong makikitang shall na salita doon. Walang sinabing shall adapt, basta adapt lang, plain. So ganito po iyon, kung may supremacy ang konstitusyon ng Pilipinas, pwede pong magkaroon ng sinasabing baring kumontra tayo sa international principles na sinasabi, mga kung anong covenant. Sapagkat kung ang ating bansa ay mapapasapanganib ang mamamayang Pilipino laban sa mga kriminal at sa mga halimaw ng bayan, papasok po yung Article 19, Paragraph 1 ng Bill of Rights, kung saan pinahintulutan ang ating Kongreso na magkaroon ng pag-aaral kung ibabalik ang death penalty at nasusulat po dyan, for a death penalty bill to be valid, ayan, nandito pa nandyan ito, as worded. Yung sinasabi pong kung may compelling reason, ayan, Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes, the Congress hereafter provides for it. Ngayon po, meron pong desisyon na controlling na hindi pa na-reverse ng Supreme Court, ang People versus Leo Exagaray, na yan po yung huling nabitay. I will quote po yung language ng Supreme Court na inilagay nila sa desisyon nila. The temper and condition of the times change, and so I think we should leave this matter to the legislature to enact its statutes depending on the changing needs of the times. Let us entrust this completely to the legislature composed of the representatives elected by the people. Ngayon, wala pong makapagsasabi na walang kapangyarihan ang Kongreso at sa kapangyarihan ngayon ni Justice Biloso bilang chairman at ng committee niya para po mag-isip, ano bang napapanahon ngayon? Meron bang compelling reasons? At mapapansin po natin na may praise dito na heinous crimes. Ang magdidefine po niyan ay ang Kongreso. Dahil sinasabi rin po sa kaso ni Leo Exagaray, I will quote from the language of the Supreme Court, per curiam or en banc. The import of the grant of power to Congress to restore the death penalty requires, number one, the Congress define or describe what is meant by heinous crimes. Kaya pag ako po ang tinanong, hindi ko sasagutin yan. Ang magdi-define po niyan ang ating mga mahal na congressmen at mga senador. Ikalawa, the Congress specify and penalize by death only crimes that qualify as heinous in accordance with the definition or description set in the death penalty bill and or designate crimes punishable by reclusion perpetua to death, in which the latter case death can only be imposed. Ayan. People versus Exagaray, GR number 117472, promulgated per curiam en banc, 7 February 1997. So ito pong pagbihiring na ito ay napapanahon sapagkat bagaman po't may COVID pandemic ay hindi pa rin tumitigil ang mga halimaw sa ating lipunan. Bakit ko po sinabing halimaw? Sapagkat walang paggalang po sa karapatang pantao ng mga biktima nila. Kaya po, dito po sa aming sapaw, nagpapasalamat po ako sa 4 na congressmen dahil yung mga bill po nila ngayon na ating tinatalakay, meron pong sinasabing special panel of senior government lawyers for cases on appeal where death penalty is imposed. Ayan, ipapaalam sa PAW agad po ng mga judges ito. Ang 4 na congressman pong nagsulat nito na may creation of special PAW lawyers, Fred Dinil Castro, Honorable Roneo Abu, Congressman Doyle Yatson, Congressman Ferdinand Hernandez. Sumasaludo po ako sa inyo sapagkat alam ko po na mga staff po, hindi lamang staff ni Manong Vicente Piloso, pati kayo po ay nakita nyo kung ilan ang acquittals ng Public Attorney's Office mula po ng inyong lingkod ay manungkula noong January 19, 2001 or about 20 years ago. 1 milyon mahigit na pong Pilipino ang napawalang sala sa kulungan sa pamamagitan ng pagtulong ng ating mga hamak na PAW lawyers. Kaya po pagkalipas ng mga panahon noong 2004 na natigil ang bitay, kayo pong mga congressman, natatandaan ko po, nandyan si Congressman Barbers, kahit yung tatay ni Congressman Biason, kayo po ang tumulong sa amin para magkaroon ng PAW Law, RA 9406. Ang panukala nyo, 1 court, 1 PAW lawyer, pinataas ang sweldo. Ang acquittals po namin noong isang taon, 2019, ay 22,471. 22,471. 2019 lang po yan. Ngayong taong ito, bagaman may COVID at internet hearing, may 5,587 na po tayong acquittal nationwide. Sa buong panungkulan ko po, halos more than 1 million Pilipinos na po na nakulong ang napawalang sala, bukod pa doon sa napababa ang sentensya. Kaya para sa akin, ay ibibigay ko po ang diskresyon at kapangyarihan sa Kongreso kung inyong mamarapatin na ibalik ang death penalty. Dahil masakit sa akin po na may mahatulan ng bitay, pero ang pangako ng mga PAW lawyers, gagawin namin ang lahat na kapag may inosente po na mahatulan ng bitay, pag inosento po ay susunod tayo sa Article 3, Section 1 of the Bill of Rights of the 1987 Constitution, no person shall be deprived of life, liberty, or property without due process of law. Kaya bibigyan po ng due process at hanggang sa Supreme Court, ipaglalaban po natin ang inosente. Ngayon, kung meron po tayong ganggahiblang duda, ako po mismo at kaming lahat makikiusap sa Pangulo ng Bansa para itigil ang bitay. Ngayon po, talagang ito pong pagkakataong ito dahil aking hinihintay, Chairman Manong Vicente, kasi nakukonsensya po ako nung mawala yung bitay na yan. Gaya nung 5 patay po sa San Jose del Monte, taga ron po ako, yung 1 taong bata, ginahasa, sinagsasaksak, yung lola na bulag, ginahasa, pinagsasaksak, 5 patay, yung asawa dumating, security guard, wala na, patay na lahat. Sino po ba may karapatang mabuhay? Yung mga halimaw o yan pong mga tao na mga inosenteng pinapatay ng mga bangag sa droga, bunga ng mga drug traffickers. Kaya po natutuwa rin ako na si Rep. Ace Barbers, kadiwa ng kanyang ama na aking best friend, binigyan pa po ako ng award noon ng PNP at DILG, na dahil kayo po ay masugid na mapag-aralang mabuti ito, nakasalalay po sa kamay ng Kongreso ito. Kung ibabalik o hindi ito. Dahil kung hindi po, mangyayari na yung mga extra heinous crimes, yan lang po ha, extra heinous crimes, ay hindi masusumpo, mas marami pong biktima ang mamamatay. Sabihin na natin, ang Pilipino may makakaliwa, may makakanan, lahat po pwede maging biktima ng mga kriminal na yan eh. Kaya kung minsan meron po tayong mga kapwa-tao na nilalagay na yung batas sa kanilang kamay, talagang pinapatay na nila yung pumatay sa anak niya o nanggahasa sa anak niya. Kasi wala nga po tayong, kumbaga ay nabubuhay pa rin kung minsan kapag walang testigo ay nakakalaya pa. Kaya po kung magpabalik po ito, maaaring dumating na talaga ang sinasabi ng ating Supreme Court na may compelling reason na. May change of time, changing needs of the times. Yan po ang language ng ating Supreme Court noong 1997. Maraming salamat po, sir, at nawa po ay nakapagbahagi po ako. Kaya yung akin pong mga deputy ay sumulat sa inyo, maging sa Malacanang, na sumusuporta sa inyong panukala na ito, na pag-aralan itong kung ibabalik ba ito. Talagang ako po, since 2004, masaya po ako noon dahil natigil ang bitay, dahil marami inosente. Marami pong nahatulan, panahon pa ni Marcos, panahon ni Cory, panahon ni Lakay Ramos, ni Erap. Pero dumating ang panahon pong sunod-sunod yung massacre. Sunod-sunod yung ang daming mga drugista na nagbebenta. Anong gagawin ng Kongreso? Manunood na lang? Kaya po yung sinasabi na diskresyon dito sa desisyon na ito, ay dapat po talagang pagpatuloy ninyo, pag-aralan nyo po, pagdebatihan nyo, at ang mga kababayan po natin, wag po kayong magagalit sa nag-object, wag po kayong magagalit sa na gustong mabalik. Pag-uusapan talaga to, pagdidebatihan para malaman kung ano po ang dapat gawin ng ating Kongreso at gawin ng ating Pangulo. Salamat po.
Mr. Chairman.
Yes, Honorable Barbers.
Thank you, Mr. Chairman. Just an inquiry, pwede na po ba tayo mag-propound ng questions after the presentation of our resource person, or hihintayin ho muna natin mag-present po lahat?
Kasi, well, ang sinabi natin kanina, every after presentation, there will be interpellation. Kasi hindi natin pwede yung buong presenters patapusin. Baka pagdating ng 3 o'clock, hindi pa sila tapos. Remember that we are already almost 2 o'clock and we have little over 1 hour na lang. Kaya nga, pakiusap ng chair dun sa mga presenters na they limit themselves to strictly 5 or even 3 minutes kung pwede, para makapagtanong naman ang members of the committee. So, in answer to your question, each resource person at a time bago tayo mag-interpolate. Thank you. So, first to interpolate would be Comsec.
Chairman, yet signify their intention to.
Mr. Chairman. Mr. Chairman.
barbers and the Honorable Vice Chair Rodriguez.
The rule we have is minority muna, and then majority, then minority, majority. Sino sa minority ang gusto mag-interpolate? Kung wala, the chair will recognize Chairman Rufus Rodriguez. Wala ba,
Chair,
Sec?
I have pending questions to the PAO.
Okay, thank you. The chair recognizes now the Honorable Franz Castro.
Yeah. Thank you, Mr. Chair. So, thank you dun sa position ng ating PAO, yung PAO. So, ang question ko lang po, Mr. Chair, yung tungkol doon sa meron po ba tayong data kung gaano po katagal, sapat po ba yung ating mga personnel para sa PAO, especially po dun sa mga poor, sa mga mahihirap nating mga kababayan na maakusahan on heinous crime. At gaano po katagal, Mr. Chair, yung on average, yung pagre-resolve or decision ng kaso kaugnay ng mga heinous crimes po. Meron pong data ang PAO.
With the permission of the Honorable Chairman, meron po kaming data nasa website natin sa www.pao.gov.ph sa ating accomplishment. Ngayon, ang tagal po ay depende sa availability ng judge, availability ng piskal. Pero yung PAO po, lagi po tayong may naka-assign, 1 PAO per court. At kami po, ang bawal na bawal po, nagagalit po ako pag nagpapapuspon yung mga PAO natin. Yung pong masisipag, binibigyan po natin sila ng mga incentive at nagjo-duty. Isa pong example ay yung isang Gabriela natin na si Maridel Torres. Ako pa nga po mismo ang nag-appear at nag-present ng witness niya doon sa mga unang hearing. Kasama ko po ang karapatan coordinator na si Jigs Clamor dahil naniniwala po ako inosente si Miss Maridel Torres dahil bagong panganak po siya nung siya ay hulihin. So ang punto doon ay umabot ng halos mahigit 2 taon sapagkat mula po sa Impanta Quezon ay dinala pa dito sa Taguig yung kaso. Nagpalipat-lipat po ng korte yon. So wala po sa kontrol ng PAO yon. Kami po sa PAO, mas matapos namin ng maaga, masaya po kami dahil marami pa pong padating na kaso kaming aasikasuhin. Acquitted po si Maridel. At talagang nagsaya po kami dahil sinasabi siya ay leftist, siya ay ganito. Pero naging patas po ang judges, naging patas sa mga piskal, talagang nalaman ng katotohanan na inosente siya. Kaya po, kung gusto nyo po ng mga data ng acquittals namin, reduction of penalty from life to 10 years imprisonment, to prison mayor, to prison correctional, meron po tayong data sa website. Very transparent po tayo sa ating transparency seal. At ISO na rin po kami certified, ang Public Attorney's Office. At nagpapasalamat din po ako sa Pangulo ngayon sapagkat ang DBM nagpadala po ng mga new items. Hindi lang po ako makapag-out dahil MECQ na naman. Dapat may o-taking po kami ngayong buwan to. Kaya lang, nababalang po kami. Every month po, meron tayong o-taking sapagkat yung PAO po, siyang nagiging source na magiging mga piskal, magiging judge. Kaya nalulungkot din ako, yung mga na-train ko po, pagka after 2 to 3, 5 years, magpipiskal, magja-judge. Pero hindi pa rin dahil karangalan po sa akin, nakapag-train po ako ng mga lilipat na magiging matapat. Kaya salamat din po sa tanong niyo, ma'am. Pero talagang ginagawa naman po namin ang lahat para magkahustisya para sa lahat. Hustisya sa akusado, hustisya rin sa biktima.
Okay, so how would you assess po yung justice system natin in terms of doon sa pagre-resolve po ng mga kaso? So alam ko naman, very passionate kayo doon sa mga kaso, lalong-lalo na po yung paglabag dun sa mga karapatang pantao. So, tingin niyo po ba nailatag na ng justice system natin yung tingin nating kondisyon para doon sa akusado man yan or complainant ay talaga mabigyan ng hustisya? Kasi ito po kasing death penalty na to, although magkaiba po tayo ng ng pananaw, tingin po natin isa sa dapat na ma-improve ay yung justice system natin. Katulad nga niyan sinasabi niyo, hindi naman kayo yung halimbawa ang merong problema, mga judge or mga so kulang talaga yung mga judges, yung mga korte natin at iba pa. So paano niyo to may assess?
Ganito po yun kasi in fairness sa Congress, masipag din ho ang House Committee on Justice na mag-approve ng mga bill na mag-create ng branches of courts. Ang problema ho ngayon, wala pong nakaupong judge. Talaga yun, aminin ko, pasensya na po yung tatamaan. Sana po lahat ng court mapil-upan ng judges. Para po yung mga kaso hindi magkalipat-lipat. Pag walang judge, ililipat sa kabila o na-transfer ng judge. Talagang kailangan mo yan kasabay ng pagpasa ng death penalty law. Ayan po, isabay yung pagpipil up po niyan at pati lahat ng items sa tatlong actors, PAW, Piskal at Judge. Kailangan mo talaga yan para, kasi sinasabi ho natin, Ma'am Franz, 1 minuto, 1 segundo ka makulong, wala kang kasalanan, injustice na yun eh. Kaya po, kailangan talaga pabilisin kung ano po yung magagawa na mapabilis lahat. Pero sa criminal case po, in fairness sa ating mga judges, mas mabilis po sila kaysa civil cases. Yung civil cases, napakatatagal po talaga. Nauna na.
Castro,
Ma'am,
Honorable Castro.
Mr. Chairman.
Yeah, are you done, Honorable Castro, Franz Castro? Tapos na po ba? Comsec?
Medyo internet ko, no? So, yun po yung isa ko pong concern, ano, yung sa justice system natin, no, kaugnay nitong sa death penalty. So, nakikita natin, tama si, si Pau, si Chief Persida, na talagang kasabay po nito, siguro, ay yung pag-aayos ng justice system natin para doon sa sinasabi nating, doon sa death penalty. Pero, yun pa rin po, the same pa rin po yung posisyon po natin hanggat hindi nakikita natin hanggat hindi maayos yung ating justice system ay talagang hindi po requisite po yun para dun sa sinasabi po nating death penalty. Mr. Chair, doon na lang po ako sa mga susunod na mga resource person po.
Thank you. Next to interpolate is Chairman of the Constitutional Amendment Committee, Honorable Rufus Rodriguez.
Thank you. Good afternoon, Mr. Chairman, and good afternoon to our PAW Chief, Percy Rueda. Good afternoon.
Afternoon po, sir.
Yeah, let me confirm, Mr. Chairman, that the Honorable Persida Rueda was a professor in San Sebastian while I was dean from 1991 to 1998, and we were honored and we thank her for helping San Sebastian reach a level of standard that has improved our law school. And he taught with us, and we thank her for that. So my question, Mr. Chairman, is the Honorable Presi Rueda has stated that indeed, in the case of People versus Echegaray, June 25, 1996, said that indeed the country and the legislature, because of changing needs, can impose the death penalty. Now, is our head of the PAO aware also that after People versus Echegaray, 1996, the Philippines had become a signatory of the second protocol of the International Covenant for Civil and Political Rights on November 2007.
Yes, sir. I know. Alam ko po, signatory, pero meron po tayo sa konstitusyon na hindi po tayo mai-stop kung magkakaroon ng pagbabago para mag-fit sa pangailangan ng national security and interest. Sabi po sa Section 7, Article 2 of the 1987 Constitution, the state shall pursue an independent foreign policy. In its relations with other states, the paramount consideration shall be the national sovereignty, territorial integrity, national interest, and the right to self-determination. So kung napapanahon po ngayon, sir, kailangan, kumbawa, yung mga nambobomba, terorista, yung mga gusto sakupin ng bansa natin, ng mga foreigner, no, terrorist, Eh wala ho tayong magawa, nakakatakas eh. Kaya nga po nagkaroon ng terror law. Kaya ang punto lang ho ngayon, pwede pong ang Kongreso, sinasabi nga po sa Executive Doctrine of 1997 by the Supreme Court, may discretion kayo po para pag-aralan nyo ano ba yung mga compelling reasons na yan, ano ba yung mga heinous crimes na yan na pwedeng maging dahilan sa bisa ng supremacy of the 1987 Constitution na ibalik ang death penalty. Yun po yun.
Thank you.
Opo, sir.
Thank you, our Chief Rueda. The provision that you have cited is not apropos to the issue of death penalty. We're not talking about independent foreign policy in relation to nations. We are talking about the abolition of a death penalty through the second protocol. This provision on independent foreign policy is how we treat other nations, with comity, with amity, and all of that. But it has nothing to do with the death penalty. But what is present, Ms. Rueda, is that there is a second protocol after the decision of the Supreme Court of 1996. And this is 2007, the second protocol. And the second protocol of the ICCP has committed that our country has committed not to execute in our jurisdiction any person in this country in our jurisdiction. And so what has been stated by the people of Echegaray, that indeed we, as a Congress, has the discretion to be able to impose death penalty on compelling reasons for heinous crimes. This provision has now to be reconciled with our commitment in a treaty. This is the second protocol. And so therefore, what has been stated there has been changed. The conditions have changed. From 1996, people with Echegaray has changed already into 2007, and also the other two conventions of the Single Convention on Narcotic Drugs and the United Nations Convention of Illicit Travel of Narcotics Drugs, where only imprisonment or deprivation of liberty has been provided in these two conventions and not a death penalty. So therefore, clearly, this is not in pursuance to independent foreign policy. That provision has nothing to do with the imposition. What is the provision here is Section 19, Paragraph 1 of Article 3, the Bill of Rights, which says the Congress can be through compelling reasons. But again, that provision of the Constitution has again, because of our Article 2, our state policy, that we have therefore adopted the general accepted principles of international law as part of the law of the land. And this is now a different matter, because this is now, we have our commitments is international law. So what can you say about that, Ms. Rueda, about the fact that the people of Echegaray was 1996. We now have a commitment under 2007 of the second protocol of the ICCPR, and also the two conventions of the illicit travel of illicit drugs, and also the convention of the national narcotics drugs. So what can you say about that? That the decision will not be the same as when there was no commitment yet of the Philippines to the international community on the death penalty.
Sir,
Yes.
with the permission of the Honorable Chairman, ang nag-enter po ng kontrata sa ibang bansa ay ang executive, hindi ang Supreme Court. Pero yung Executive Doctrine po yan ng ating Supreme Court, which is an independent from the executive branch. Hindi po pwedeng automatically marirevoke ng executive ang Supreme Court. Yung po yun, sir. Kaya yung pong mga subsequent na yan, contrary ang essence sa Executive Doctrine, which is controlling, hindi po natin pwedeng sabing stare decisis na versus the Supreme Court. Kaya tayo may three branches of court: executive, legislative, and the judiciary. Ngayon doon po sa Section 7 of Article 2 of the 1987 Constitution, dalawang sentence po yun eh. Yung isa, the state shall pursue an independent foreign policy. Pero meron pong karugtong, in its relations with other states, the paramount consideration shall be the national sovereignty, territorial integrity, national interest, o kasama po sa national interest and national security. Yung po kasing pwedeng sumakop sa atin, napupunta sa atin, na pwedeng patawan ng death penalty dahil papatayin tayo, bobombahin tayo, pasok po dito sa pakikipagrelasyon natin sa ibang bansa dahil yung kanilang mga tao ay pwede makatulan dito ng death penalty. Kaya nga po ang UN, bumuo sila ng asosasyon para po magkaroon ng palsiya na walang death penalty. Bagaman po, tayo na nga lamang po sa Asia ang talagang nag-suspend ng death penalty. Kaya ito pong Section 7, sir, ay napakaliwanag. Hindi lang tumutukoy sa relasyon natin panlabas, kundi kung ano yung magiging batas ninyong gagawin dito sa loob na dapat igalang po ng mga nasa labas. Na hindi tayo po questionin, sasabihin magagalit yung UN Council, yung ganito, dahil binalik natin ang death penalty. Kapag tayo po ay may national sovereignty, napaka-importante po ng ating national sovereignty dahil yan po ang ating identity sa buong mundo. Ang Pilipinas, malaya na. Hindi na po tayo sakop ng banyaga. Ngayon, hindi po tayo under talaga ng UN. Tayo po may sariling gobyerno na dapat magproteksyon sa taong bayan laban sa mga halimaw ng lipunan. Ngayon, sino po ang dapat nating proteksyonan? Yung humanity sa ating bayan, whether citizen or foreigner. Paano kung wala pong katatakutan na yung mga yan, sabi nyo ba hindi sila natatakot? At least po, kung may death penalty at talagang proven, beyond reasonable doubt, after appeal, talagang sila talaga yan, malakas ang ebidensya, hindi na po papatayan dahil talagang makukulong na siya habang buhay. Kaya nangangako po ako sa taong bayan, ang mga PAW lawyers po natin, hindi po titigil yan kung inosente ipagtatanggol hanggang sa taas-taasan para wala pong mamatay na inosente.
Well, thank you, Ms. Rueda. Now, certainly, we are not saying the Supreme Court should follow the executive. We are saying that the Supreme Court follows the Constitution. And the Constitution under Article 2, Section 2, says that precisely the Supreme Court has to follow this. We adopt the general principles of international law as part of the land. That's what we're saying. So we're not saying that it should follow the executive's handling of this treaty, but clearly this treaty is now part of international law, part of the law of the land. And that is why the Supreme Court in 1996 has yet they cannot project that we in 2007 would have already signed the second protocol, which is now part of the law of the land, and that in 2006, after the 1996 People's Echegaray, in fact, enacted 9346, considering everything, considering heinous crimes, considering propelling reasons. And therefore, we cannot therefore use the People's Echegaray to be a basis to say that we can implement that now. At the time, as I will reiterate, there was no approval yet or ratification of the second protocol of the International Covenant on Civil and Political Rights. Now, you have given us some history of the law, of the abolition of the law. You said that you have a big hand in the passing of Republic Act 9346, and you told us emphatically here that in the cases of Likayan and the other one, a bishop approached you and you saw that there were really conflicting evidence, and there was no direct evidence that these two were guilty, that they should be meted the death penalty. And you argued in the Supreme Court for hours to say that there is no evidence against this person already convicted of crime that will entail a death penalty. So clearly, you have stated that there is a situation where our courts would convict people and mete out the death penalty, and they were wrong. And precisely as you have said in the case of Likayan and the other accused, you were able to convince the Supreme Court, and the Supreme Court suspended the implementation, meaning that it is very possible a poor person charged in court, unable to get good lawyers, are precisely convicted in the lower court and in the upper court until it reaches to the Supreme Court, that they actually have no evidence, but because they could not get the best lawyers, they are convicted. So you have said that precisely. Now, you also told us that you were part of the approval of the the 9346 prohibiting the imposition of a death penalty. Can you tell us your actual participation in the Congress being able to lift and to prohibit this death penalty in 2006, Ms. Rueda?
Gaya po ng sinabi sa desisyon ng Supreme Court sa Isagaray, kapag may pagbabago po ang sitwasyon.
No. I'm asking you how you help in the new law 9346, which is the law that prohibits death penalty, which you said you have a part because you started it by going against the decision in Likayan, and you were able to get that suspended. You said, so you help our Congress pass the law that will prohibit death penalty. Is that correct?
Because we assess po, hindi po pa panahon na convict yung mga tao na yon. Panahon pa po
na, nasa Supreme Court na eh.
Mga na-convict noon yun.
You help.
Sir, ang pahu noon, wala pang 900. Eh, ang korte may 2,000. Tapos, nag-aralan ko po, sir, mas marami po ang may private lawyer. Ibig sabihin, nung araw, hindi sila nagtitiwala sa PAW. Kaya po kayo po, isa po sa author ng PAW law, pinalakas nyo po yung PAW. Kaya ngayon yung PAW po, paborito po ng mga akusado ngayon, kahit mayaman po, gusto patulong sa PAW eh. Kaya lang, disqualified po sa amin.
Do you confirm that you helped in Congress passing the law that prohibits the imposition of death penalty? Do you confirm that? That you helped?
Kasi iba pong panahon nun, may 1,000 pong mabibitay, 40% innocent.
Okay, so it's a fact that you were against death penalty at the time, correct, Ms. Rueda?
Yes po, kasi may mga inosente pong mabibitay. Eh, hindi ko naman po makliyente yun. Opo.
So, what I'm saying is that
pero ngayon
you...
po, iba na panahon po ngayon.
Well, that is something else. But you have admitted that you have already, because you saw that there were convictions and in the Supreme Court, you were able to have a suspension. So you actually helped during the time of President Macapagal, you helped Congress, giving your expert opinion, you helped Congress pass 9346 that prohibits the imposition of the death penalty. Correct? You helped there.
Yes, because we are saving po innocent lives.
That's all right. So therefore, you have helped there. Okay. So now, explain. So why is it that now, after 2006, 9346, where you helped in, you have seen the flaws and you have seen that this death penalty will not be for the good interest of our country, you help our congressmen and our senators approve this bill. And now, why do you have, Ms. Rueda, a 180 degrees, change in your position? Remember, you are the public attorney. You're the public defender. And therefore, you are duty-bound to help those who are charged with heinous crimes and others, and even drugs. You are doing that. And now the head herself is now saying, go ahead. You kill the accused because we believe in the death penalty. Can you tell us that sudden change, which is in conflict of your position as the public defender? You are now letting people go to the lethal injection. Is that what you're saying, Ms. Rueda?
Sir, excuse me, with the permission of the Honorable Chairman, ang PAW ngayon hindi pang kriminal lang o pang akusado. By virtue of the new law, PAW law office of the government na po ito. First come, first serve ang victim o akusado kung sino pong mauna. Kaya nga po si Dexter Carlos ng San Jose del Monte nakalapit, nakatakbo po sa PAW. Kaya kami po, first come, first serve, marami po tayong victims na tinutulungan. Victims ng bawsi, ng rape, ng murder, tinutulungan po natin. Patas po ang PAW na ginawa nyo. Hindi ito pang akusado lang o defender lang. Kaya po ang pangalan namin, Public Attorney's Office. Hindi Public Defender's Office po kami, sir. Kaya po, mapapansin nyo ngayon, dahil sa sinabi ng Supreme Court, the temper and condition of the times change. And so I think we should leave this matter to the legislature to enact statutes depending on the changing needs of the times. Let us entrust this completely to the legislature composed of representatives elected by the people. Sir, iba noon ang PAO, pang-kriminal lang kami, pang-accuse, mga nasa sakdal. Ngayon po yung ginawa mo, isa ka po sa nagtanggol sa amin, sir. Boss ko po kayo, sir, sorry ha. Yung PAO, pinalawak nyo na po ang aming kaya ang dami po namin biktimang natutulungan ngayon. Nung araw, wala pong matakbuhan ng biktima. Tatakbo sa Crusade Against Violence, tatakbo sa BACC, sa kung saan-saan. Hindi po kumano, minsan kulang din yung help desk ng PNP. Ngayon po, pagka-kriminal, biktima nauna sa PAO, magkakampi yung piskal, yung pulis sa PAO. Kaya po maraming na ipakukulong ngayon na ang kliyente naman namin yung biktima. Ang point to doon, kailan po ba madiditer ang krimen? Kung di natin sasabayan ng pag-aaral, paano po mapuputol ang mga kalimaw na yan ng bayan para po maproteksyonan ang taong bayan? Iba na po ang PAO, sir, ngayon, kaya tumaas ang sweldo ng mga PAO.
Mr. Chairman, we precise, I'm the co-author of the Strengthening the PAO. Basically, the PAO is going to help the poor and those precisely to be defended who cannot really afford counsels. What you're saying is that you're also pro-government. So are you saying now that the PAO will now connive with the prosecutors to make sure people who are guilty will be given the death penalty?
No, we will not. If
Your
na
point.
our client is...
Okay, let's not debate on this. But Ms. Rueda,
Sakis po kami.
the PAO is to protect, and especially for people who are charged with heinous crimes, your duty is to make sure that all the rights are protected. Now, you are saying
Order.
of death penalty.
Order.
Sir,
Your Honor, let's have order in our deliberations. We have barely 40 minutes to go before our session, and we still have PNP, IBP, Flag Chair Chel Jokno, INUPL Chair Nery Colmenares, and Karapatan Roneo Clamor. Honorable Chairman Rodriguez, kindly wind up your interpellation.
Yes, let me just wind up by stating, I have still many questions, but I agree with the chair that we lack material time. And so probably we would like to ask, because I have some data to ask our resource person, Ms. Rueda. For example, in this particular case, when the death penalty was abolished, did the crime go up such that there will be a change of situation? Did it go up when we abolished the death penalty, or is it the same? So we need those facts from the Public Attorney's Office. And also we need facts from the Attorney's Office on how many they have defended on those charged with heinous crimes. Although that law we cannot impose the death penalty, but the heinous crimes law is still there, except that you cannot implement. So these are the different data that we'd like to have from the PAO. And certainly, before I end, let me remind the Public Defender's Office is to defend our people, especially those who are charged with heinous crimes. The prosecution is the agency that will try to give them death through if we restore this. And the Public Attorney's Office is the office that you say, no, you cannot implement that because there are no evidence and so forth. Now, if you have the PAO, like Ms. Rueda, siding now for death penalty, now what happens to our country? Thank you, Mr. Chairman. There will be no office that will protect poor people from the death penalty. So that should be a clear delineation. Prosecution is to prosecute, make them get the death penalty if this is restored. But the public attorney should make sure that everything should be given to the poor litigant, that he should not be executed. Thank you very much, Mr. Chairman. That can proceed to the other resource persons.
The chairman of the Drugs Committee, Representative Barbers, is the last to interpolate. Is he still around?
Yes, yes, Mr. Chairman, I am around. Just a very short question, and I'll just reserve my questions in our subsequent hearings on this particular subject matter. Tanong lang po ako kay PAO Chief Persida Acosta. Sususugan ko lang ho yung kanyang sinabi kanina. Tungkol dun sa, bigyan niyo lang ho kami ng mabilisang iyong personal pong assessment tungkol po dun sa crimes o yung mga krimen na nangyari nung meron pa ho tayong batas sa death penalty at yung krimen na nangyari nung natanggal po yung death penalty. Ano ho ba ang mas grabe na mga krimen o ano ba yung mas karumal-dumal na mga krimen na nangyari sa ating bansa? Nung merong death penalty o yung walang death penalty?
Ang masasabi ko po, nung mawala ang death penalty, mas dumami po ang gumamit ng ipinagbabawal na gamot.
Okay.
Yung pagiging drug addict po, yan ang root cause ng mga violent crimes, ng mga heinous crimes. Robbery with homicide, kidnapping with homicide, at yung mga massacre.
Okay.
Kaya po ang pinaka-root cause. Dumami po. Kaya po noong mag-launch ng Drive Against Illegal Drugs, almost 1 million po ang natulungan ng PAW na mga tinulungan namin magpagamot, magparehab.
Salamat po.
Balik pagbabagong buhay, sir. Kaya napansin ko po, nung mga death penalty, yung mga durugista, yung mga nagtitinda, mga trafficker, lalo lumakas po ang loob eh.
So sa madaling sabi po, ma'am, you are also in the opinion that by imposing death penalty on crimes considered to be heinous o yung mga karumal-dumal na mga krimen, ito ay posibleng maging deterrent sa commission o sa pag-perpetrate ng mga kriminal ng ganitong klaseng mga krimen. Tama po ba yun?
Kasi ang tingin ko po dyan, tingin namin, kung sila ay may karapatang mabuhay ng matagal, paano yung buhay po nung bibiktimahin pa nila? Ngayon naman po, may due process, may apila. At napansin ko po, mula nga po noong 2001, magkakasama na tayo, ay halos 1 milyong Pilipino pong naakwit sa tulong ng PAW. Iba na po ang PAW ngayon, sir. Hindi kagaya nung araw. Alam naman yan, kahit sa constituents nyo, nababalita ang sigasig ng mga PAW lawyers natin ngayon. Yung 1 milyong acquitted doon na yun, kung may death penalty, hindi po mabibitay.
Okay. Salamat po, ma'am, doon sa iyong sagot. No? Dahil po nabanggit nyo yung due process na mukhang sa inyong accomplishment as the head of the Public Attorneys of Public Defender's Office, marami ho kayong mga akusado na nasintensyahan ng mabigat pero napabago ang sentensya sa kanila. At meron naman po ay supposed to be ay bibitayin, ngunit dahil sa inyong pagdidepensa ay nabago po ang kanilang penalty. Tama po ba yun?
Tama po yun, sir. Kaya nagpapasalamat ako sa mga kasama nyo. May provision ngayon dyan sa mga bill, special panel of senior government lawyers.
Okay.
Hindi pang biktima po to, pang death convict lang to.
Okay.
Hindi sila tutulong sa biktima, kaya wala silang conflict. Tama hutong inyong bill na to, yung ginawa nyo po.
Sige po. So in other words, dahil nakita naman ho natin na ganun ang mga nangyari, no? Masasabi natin, no? Are you also in the opinion, just like this representation, na merong due process na nangyari kung kaya't naging ganun ang desisyon ng ating Korte Suprema o ng ibang korte. Tama po ba yun?
Opo, due process po yun.
May due process pong tama.
Kasi nasa Constitution, sir, di ba? Yung no person be deprived of life without due process of law.
Yes. Ngayon, kaya ko po sinabi po yan dahil marami ho sa mga hindi sumasang-ayon na maibalik itong ating death penalty bilang parusa sa mga karumal-dumal na mga krimen dahil according to them, there is now an imperfect justice system. Now, kayo po ay practitioner. Kayo po ay officer of the court. Kayo po ay may experience sa larangan ng due process.
Opo.
Binanggit niyo po kanina. Ngayon, kung kayo po ay tatanungin ko, total tayo lang naman ho. Wala namang ibang nakakarinig. Yung buong
Pero po, nakalive po tayo, sir.
Yun nga ho, yung buong Pilipinas lang ho nakakarinig.
Opo.
Sa inyong personal na conviction o sa inyong personal na opinion, is there an imperfect justice system?
Ang sagot ko po dyan, case-to-case basis, court-to-court basis. Kasi po, kung merong judge na salbahe o corrupt, nakararami po matitinupang judges. Katunayan po, ilang judges na ba naambus at napatay? Nasaan yung pumatay? Buhay pa rin, pumapatay pa rin sila. Ang nakalibing yung mga judges na matitino. More or less 50 fiscals, prosecutors and judges na po naambus. Mga lawyers. Ayan po ang IBP president natin, si Atty. Cayosa, isa po nagdurugo puso namin. Mas may karapatang mabuhay yung mga nang-aambos.
Yeah.
Pumapatay kaysa doon sa matitinupong mga kabaro natin sa abogasya.
Correct. Doon nga po sana ako pupunta kasi marami po tayong mga fiscal, mga practicing lawyers, mga huwes, mga judges na naging biktima rin ng krimen gaya ng pag-aambush, pagpatay, no. In fact, sa mismong distrito ko, dalawa ho ang judges na inassassinate, no.
Opo.
At marami pong anggulo, and most of the angles na lumalabas dun sa usapin ng kanilang pag-ambush sa kanila ay tungkol sa mga kasong karumal-dumal na nahawakan nila. In other words,
droga ang hawak nila drugs.
Yeah, correct. So, dahil nga you are also in the opinion na hindi naman imperfect yung justice system di po ba?
Tama po yun. Wala namang taong perfecto po Kahit po, wala po talagang perfecto, pero ang importante, majority po ay tumutupad sa kanyang sinumpaang tungkulin.
Meron po akong bibigay na example, ehemplo lang ho. No? Halimbawa kasi napag-usapan din kanina, napahapyawan din kanina sa usapan ninyo ni Kong Rufus Rodriguez tungkol dun sa ating mga treaties, mga covenants that we are a signatory to, no? The Philippines is a signatory to. Nabanggit nyo rin kanina, you cited even the provision of the Constitution on the foreign policy. Kunyari meron nung isang Indonesian, no, na pupunta rito, and God forbids, no, may binomba na kung saan maraming Pilipinong namatay. Sa tingin nyo, atin-atin lang din ulit. Wala naman itong nakikinig. Sa inyong pananaw, ano ang karapat-dapat na parusa sa ganun?
Alam nyo sir, pag hindi yun nakasuhan, nakatulan ng bitay, marami pa bobombahin yun. Papatayin, pwedeng tayo.
So, in other words, pagka ganun po, in other words, kayo po ay sumasang-ayon.
Doon sa extra hinus talaga.
Yung talagang ika nga karumal-dumal. For lack of
uulit
better...
pa ho yan Uulit pa ho yan.
Last point na lang po, ma'am. Mr. Chairman, last point na lang po. I know that we're running out of time, no? Yung po mga oppositionist o yung pong ayaw o hindi sang-ayon, isa sa kanilang itinutulak na issue ay sabi nila ay anti-poor daw po ito na panukala. Kagaya nung nasabi nyo kanina at ipinahayag dito sa ating meeting na sa accomplishments ng inyong opisina at ng inyong mga kasamahan dyan sa buong PAO, nakita naman natin na karamihan ng inyong dinidepensahan ay...
Mahirap po, mahirap.
Sure, sinabi nyo na, no? Mahihirap. Ngayon, meron bang puwang sa usaping ito na itong panukalang ibalik ang death penalty ay isang anti-poor na legislation o anti-poor na batas?
Para sa akin, dahil pinatatag niya yung PAO, may bantay po ang mahihirap laban sa maling pagbitay.
Okay, maraming salamat po.
At po ang inyong hirap sa inyong pagdi-deliberate ng PAO Law of 1997.
Salamat po sa inyong...
9406, Republic Act 9406 po yun.
Yun, tama po. Kasi nga yun ang mga itinutulak ng mga oppositionist na mga issues. Marami pa nga silang mga sinasabi na dapat hindi mapasa ito dahil po sa mga ganitong mga punto. But I will not belabor that point anymore kasi darating naman yung tamang oras para sa ganyang argumento o sa ganyang usapan. So with that, Mr. Chair, yun na lamang po muna sa ngayon at hopefully in the next subsequent hearings of your committee, Chief Persida Acosta will still be available. Maraming salamat po. Magandang hapon.
Salamat. Time management lang po, no? We have about 25 minutes to go. Ang invited to speak are representatives of PNP, IBP, then si Flag Chair Chel Jokno himself, EU PL Chair Nery Colmenares, Karapatan Representative Roneo Clamor, and Bishop Mangji. Ganito na lang, dapat Comsec hindi ganito kadami ang i-invite natin kasi talagang kulang na kulang ang isang araw for presentation of position ng resource persons at lalong mas marami pang panahon ng kinakain sa interpellation. But for this 20 minutes that we have, I would suggest, sino ba sa pinangalanan natin ang available for presentation, and I will, the chair will give them, siguro pwede pang 2 or 3 minutes. After all, magbibigay naman sila. The committee will be requiring them to submit their written position on the matter. Sino sa anim na pinangalanan ko ang handang magbigay ng posisyon? Kasama na si Bishop Marigza.
Mr. Chair?
Yeah.
Mr. Chair?
Yeah. Yes, Nobel Monte.
I'm sorry, Mr. Chair, I just got back online. Na-traffic ako papunta dito sa HOR. I don't know if my question was asked or if it's appropriate pa po kung pwede lang po ako magsingit ng isang tanong kay Ma'am Presi before we move on, Mr. Chair? Or did I miss my opportunity and the next time na lang po?
Pwede ba sa, well, okay, Honorable Acosta, isang tanong lang po. Sige.
Sige po, sir.
Thank you very much, Mr. Chair. Ma'am Idol. Ma'am, it was pointed out to me on the way here na mayroon kayong dineliver na statement sa isang noong 2005 sa Waterfront Hotel ata ho ba yan sa Cebu or if I'm not mistaken, saying na hindi po at actual na deterrent po ang death penalty. And in fact, if parang the first part was gaano ka-active yung PAO para protectionan yung somebody who was mistakenly accused and mistakenly convicted sa death penalty. May I know, ma'am po, kung ano yung nagbago between that period and now? Bakit ho nag-iiba po yung position niyo po? Just for my enlightenment po.
Ano po yan? That was 15 years ago, 2005.
Opo.
Months after the abolition of death penalty at months bago po kayo, yung Kongreso ay isuspend yung execution noong June 2006. Pagitan po yan ng aking oral argument sa Supreme Court kung saan nasuspend executions at yung pag-approve nyo po ng abolition noong 2006. Sinabi ko po talaga noon yan na hindi deterrent dahil nung araw, kahit may death penalty, meron pa rin pong gumagawa ng mga krimen. Alam naman natin yon. Pero nagbago po ang panahon eh. Uso na po ngayon ang bombahan. Yun nga pong Marawi, kung hindi po may nakapagtip na may nagtayo na po ng bandila ng ISIS doon, sinakop ang BGMP, ay wala po, yung buong Mindanao, ano po yun, nasakop na tayo ng mga terorista. Kasi nga po, itong bansa natin, napakaluwag po ng sistema. Hindi kagaya ng ibang bansa na katabi natin, na talagang napakahigpit ang kanilang batas. Naging maluwag po tayo mula noong 2004 na yan, 2006, at hanggang ngayon po. Kita nyo po, yung mga bumapatay, nga, 50 na po, ngayon lang, 2 taon lang po, 59 na patay na judges at prosecutors. Paano po hindi magbabago ang aking pananaw ngayon? Sino pong may karapatang mabuhay, yung kriminal o tayo pong dalawa, Sir Kit? Yung mga anak natin, sino may karapatang mabuhay? Sila? O tayong lahat na matapat sa Diyos? Yung pong tanong ko sa sarili ko. Kaya sa totoo lang po, pag nakakabalita ako ng inambus, yun pong Secretary General PCSO, inambus na isang araw. Yung taga National Center for Mental Health, yung head, pinatay, inambus. Nagdurugo po puso ko. Minsan sinisisi ko sarili ko eh. Bakit po ako gumawa ng isang hakbang na lahat na po ng bibitayin, pinatigil ko na pong bitayin. At ako po ang mismo nakiusap kay President Gloria noon. 3 sulat ang pinadala ko. Ma'am, wag mo pong bitayin yung 1,000 na yan. At salamat sa Diyos, pinagbigyan niya ako. At nireview po namin, about 30% po doon, nakalaya pa po, nakauwi. Yun nga po yun eh, nabigyan sila ng chance. Ngayon, ang aking prinsipyo ngayon, kung sintensyahan ka, ngayon, inosente ka, ilalaban sa apila. Kung sa apila, wala pa rin makuha, may gaganghiblang pag-asa, ako po mismo ang tatawag sa Pangulo ng Bansa, huwag mong bitayin yan. Dahil may duda dyan. Ganun po yun eh. Opo. Thank you po.
Thank you, Ma'am President. Thank you po.
Next is
Thank you, Mr. Chair.
again, we will limit ourselves to 2 minutes na lang without prejudice to your submission of a written position on the matter. PNP. At wala na po tayong interpellation after this, no? Hanggang matapos lang muna yung mga resource persons. Maraming salamat po para magkasya itong 20 minutes.
Sir, sandali lang, isang sentence lang, sir. Sir,
Okay.
Chairman,
Yes.
isang sentence
Chief.
lang po.
Okay.
Video mo.
Go ahead, Chief Acosta.
Nawala na. Yung pong mga tratado ay pwede pong i-repeal ng statute na gagawin nyo. A statute may repeal a treaty. Yan po ang principle of lex posterior derogat priori. Nasusulat po yan at pwedeng i-research sa mga law students pong nagmo-monitor ngayon. Ayan po, nasa kaso po yan. Ito ba yan? Secretary of Justice versus Lanchon, January 18, 2000, GR 13-9465. Yun lang po, sir.
Okay, maraming salamat. Salamat, Chief Acosta. Okay, PNP. Wala ba? IBP. Kumsek.
Ready, Your Honor.
Secretary kayo, sir. You're recognized.
Thank you, Honorable Chair. Good afternoon to everyone. Thank you again for inviting us to this committee hearing. The Integrated Bar of the Philippines does not advocate a return to the death penalty regime for the following reasons. Number one, it runs counter to the reformatory approach to penology, which is a globally and a United Nations recognized standard for prison reform. Secondly, there is no statistically and sociological studies would show, and we are very much willing and glad to share with the committee secretariat the studies, statistical and scientific studies that would show this data. They would show that there is no direct correlation between criminality, including drug cases, and the death penalty. Third, the death penalty is not the best solution to the criminality or the drug problem. Fourth, the Philippine government is a signatory to various treaties that would be violated, or we would turn our backs to these treaties if we go back to the regime of death penalty. In an imperfect justice system, which most of the honorable congressmen admit and everybody would recognize, such as what we currently have in the Philippines, the death penalty is statistically anti-poor. Because if you look, Your Honors, at the data of the Supreme Court, a vast majority of those who were convicted belong to the poor. Secondly, the data from the Supreme Court, no less than the Supreme Court, in People versus Mateo, has recognized that in all of these trial court convictions on death penalty, 71.77% of these were reversed by the Supreme Court. There is also data that shows this too long until case involving the death penalty is finally resolved by the Supreme Court, because under our current laws, Your Honors, if we go back to the death penalty, it will automatically be reviewed by the Supreme Court. And the statistics of the Supreme Court would show, and the justice sector would show, that it takes from 5 to 15 years to finally resolve cases like this. Now, we fully agree and respect the authority and the duty and the power of Congress to enact laws and set policies. It is true that the Congress may restore death penalty, but the Constitution provides a standard, and it says for compelling reasons. And compelling reasons, if you look at the meaning, is powerfully irresistible. To our mind at this point, because of the foregoing data, the sociological studies that shows that with or without death penalty, the crime rate or even drug-related cases do not really have any direct correlation. We are hard put to find a compelling reason. However, Your Honors, in the exercise of your legislative powers or prerogatives, if you, in your own research or consultation, you find compelling reason to disregard the statistical data, the sociological studies, the United Nations and globally accepted reformatory approach, our treaty obligations, our standing in the international community, then we would like to suggest, similar to what Representative West Gatchalian was suggesting, that it should be very specific and clearly limited. And that would be, though of course, still the data available with the DOJ, with the PIDEA, and with the justice sector shows there's really no correlation. But if you find a compelling reason, we suggest that it should be limited, clearly specified to high-level, high-profile, large-scale, big-time drug offenders. And this is a personal observation, Your Honors, because the IBP president sits in the Dangerous Drugs Board. And we have assiduously looked at the history and the records. It appears there that the real big-time syndicates are all foreign-connected. And that's why, if ever you find compelling reason, we suggest that the death penalty be applied only to high-level, high-profile, big-time, large-scale drug traffickers who are foreigners and their collaborators. We believe, Your Honor, that another more important really is the most important that we would like to point out is that there should be prerequisite measures to improve the speed, efficiency, transparency, and accountability of the justice sector, and for Congress to provide budgetary support for this much needed improvements. I think all the pillars of justice would tell you, Your Honors, that we need to improve our justice system. It's slow, at times corrupted, influenced, and no amount of penalty will deter and scare our people, or much more to the hardened criminals and syndicates, if they know they can go around our policemen, our fiscals, our judges, and even our wardens. It is very important that this be made a prerequisite. You wouldn't need much laws on this, but we hope that you would consider looking at this, because no amount of penalty will make a difference. It will not be a deterrent if they know they can get away with it. We are pleading that we focus on better ways of addressing the drug problem that have direct correlation to the serious drug menace that we have. We understand and share the frustration of the president about the drug problem because it now appears that death does not or has not solved the drug problem. Records of the PNP itself and many other groups would show that despite the deaths of thousands of suspects, of criminals or drug dealers in the government's drug war, the drug problem remains. So that should be an eye-opener. The other thing, Your Honors, is that if the vision is that if you pass a death penalty law for drug traffickers now, we will see a succession of death penalties. It will not happen during this administration. Why? Simply because the law will have prospective effect. And if you look at the track record of the justice sector, it will take so many years before a final conviction is done. So it will take perhaps another 5 to 10 years before we see an actual execution. So the deterrence that we hope, or that the sponsors of the bill hope will happen, will come much later. Another point that we would like to raise, Your Honors, is that if ever you would wish to have death penalty in this country, and we see different ways or different proposals of executing these criminals, may we respectfully point out the provision of the Constitution against cruel and degrading punishment. Now, with respect to our international commitments, Your Honor, of course, government can turn away or walk away from these treaties and conventions which were approved by our government with the concurrence of Congress. Now, if we do that, of course, as many have said, it is our sovereign power. It is correct. We can actually walk away from these commitments, but there will be repercussions economically, diplomatically, and we are now, as we know, in a pandemic, and the global economy is so interconnected. Trade, even the fate of our OFWs, as amply discussed by many of the presenters and the lawmakers, there will be repercussions. So perhaps it would be good for the honorable members to weigh between the death penalty and the so many repercussions it may have, not only in our national life, but also in our international relations. Lastly, Your Honors, if the intention of the proponents of the death penalty is really to scare or to deter these continuing drug syndicates, or are people to walk away from drugs or avoid drugs, be worried. Let us be worried of possible reverse effect. Why is that? Because assuming tomorrow you pass the death penalty law for drug offenders, it will take so many years before we actually have an execution. Our people will just again say, oh, meron ng death penalty, wala naman nakukonvict, wala naman na-execute. Because traditionally, statistically, our justice system is very slow. So imbes ho na makakatulong, sasabihin na wala namang kwenta yan, pare-pareho din lang naman. So let's just be worried about those possible reverse consequences of passing the death penalty. It might not be the best approach to the noble intentions of deterring crime. To our mind, and I suppose the other pillars of justice, the DOJ, the judiciary, the police, the parole system, the prison system would tell us, and the experts would tell us, there are many other ways by which Congress can really support the drug war, aside from reimposing the death penalty. Ang punto lang ho namin if there are other avenues by which within which Congress and government can act, why not pursue this instead of the more troublesome and contentious return of the death penalty? Thank you very much, sir. And we are willing to submit to your committee the statistics and the studies supporting the stand of the Integrated Bar of the Philippines.
The committee will also inform Attorney Cayosa of the next hearing. Please be available for interpellation. Thank you. Next is Flag Chair Chel Jokno.
Thank you, Mr. Chair and Your Honors. The Free Legal Assistance Group Anti-Death Penalty Task Force is firmly and unconditionally opposed to the death penalty and its reimposition. First, because the death penalty does not deter crime. Second, because it is anti-poor. And third, because it violates the Constitution and our international obligations. When we look at the data coming from the Philippine National Police, it shows that since we abolished the death penalty, the crime volume has gone down. It also shows that during the time we had the death penalty and were carrying out executions from 1998 to 2002, the crime volume for rape in particular went up. So that this would pretty much show that the death penalty is not a deterrent when it comes to crime. It is really the certainty of being caught and punished that deters crime, and not the severity of the punishment. And that is why our position is that the only real and lasting solution to criminality is to strengthen the justice system. No amount of death penalty laws will work without what we need to be focusing on is to increase the conviction rate, to speed up litigation, and to fill the vacancies in the judiciary and in the prosecution service. That the death penalty is anti-poor and it unduly discriminates against the poor was shown by a survey that FLAG conducted in 2004 when there of death row inmates. We found that 73% of those on death row at that time were poor and unlettered, and that 81.8% of them had very low income jobs. In fact, we estimated the cost of defending a death penalty case, and the conservative estimate is about 300,000 pesos. And definitely that is way beyond the means of many of those who were at the time charged and later convicted of given death penalty sentences. I would like to address, given the rest of my time, I'd like to address some of the things that have been mentioned earlier in this meeting. This is with regard to the violation of treaties that we willingly and voluntarily signed and ratified. I'm referring to the International Covenant on Civil and Political Rights and the second optional protocol. It's not true. Hindi po totoo yung sinasabi nilang may conflict between the Constitution and these treaties that we have signed. There is no conflict when one law is permissive and the other is prohibitive. In fact, the fact that our Constitution allows Congress to impose the death penalty under certain conditions cannot at all change the fact that we have an international obligation not to reimpose the death penalty. Hindi rin po totoo na tayo lang ang bansa sa Asia na walang death penalty. There are about 13 other countries in Asia that have abolished the death penalty. Cambodia, way back in 1989, Nepal, Turkey, Armenia, Azerbaijan, Bhutan, Cyprus, Georgia, Mongolia, Timor-Leste, and all of these countries have abolished the death penalty. And in particular in ASEAN, we have 3 countries that are abolitionist in practice, meaning that no executions have been done in these countries in the last 10 years, and that is Brunei, Laos, and Myanmar. So for these reasons, we are vehemently opposed to reimposing the death penalty. May I just add that as far as our international obligations are concerned, because we have signed and ratified these treaties, these are legally binding obligations on the country. We cannot just turn our back on these obligations, especially considering the fact that we are under a state of pandemic where there are so many other priorities that we should be paying attention to instead of things like this death penalty. For these reasons, we would like to register our opposition. At the same time, may I just make it of record that we have already submitted our position paper to the committee. Thank you.
Attorney Jokno. Next is NUPL Chair Nery Colmulares.
Thank you. Thank you, Mr. Chair. Good afternoon. It's nice to see old friends and colleagues, even if virtually. Maraming salamat po, Chairman Vicente, and thank you very much for this opportunity. I have a slide, just short, 5. I'll probably cut it even to 4 slides na lang, if the ComSec can show it. But basically, just a brief discussion lang on the various penology philosophies. The first is, of course, retribution. The retribution is an eye for an eye. That has been there for, ages. Panahon ng mga hari, panahon ng mga, barons. And it became dominant probably ng mga 18th century, 19th century, nawala na ang dominance niya because new penology, philosophies came in. Ipaki-focus lang yung slide, please. The second is, may problema kasi sa retribution kasi you cannot really gouge the eye of a person who blinded another. Nor pag nagnakaw siya ng tinapay, hindi mo naman pwedeng nakawan siya ng tinapay. Pero kung putulin mo naman ang kamay niya dahil nagnakaw siya, parang sobra naman ata. So hindi nag-gain ng prominence ang retribution later on. At later, Mr. Chair, can the ComSec point it to the slides itself? Deterrence, of course, is a theory that came in. Ang deterrence is that you discourage future commission of the crime kasi, di pa mamarisan. Kaya lang may mga studies na, lalo na yung capital punishment, deterrence, as mentioned by Dinchel, hindi naman deterrence actually siya. So, marami pa rin krimen ang nangyayari even if may capital punishment. I'll discuss that later. So ang isang is preventive theory, meaning to say ikulong mo or ipatayin mo to prevent the repetition of the crime. Doon sa kulong, ang problema doon, nagnakaw siya ng cellphone o tinapay muna, tapos paglabas mo sa kulungan, abay lalong lumala ang krimen niya. No? So nagkaroon ng rehabilitative or yung restorative justice na tipo na i-rehabilitate mo ang mga nakakulong. So I'll end it there. Ang penology philosophy, according to the Bucor, sa ngayon, I've heard so many officials from the prisons authorities na rehabilitative ang ating philosophy ngayon. So, now, I'll go to the next slide. Hindi naman na, can the slides hindi makita, no? Anyway, I'll just go straight na lang to the third slide. There is no proof that death penalty deters crimes. Doon na, kasi ang main reason talaga ng maraming proponents, wala pa yan noon when I was in Congress, has always been deterrence. Ang main reason nila. No? So, in 1999, when Echegaray was executed, ang national crime increased by 15.3%. So, nag-increase despite the execution of Echegaray. In 2007, when death penalty was abolished, there was a 7.4 reduction in crime. Okay. Crime rate decreased in 2010 to 2012. Walang death penalty noon. Pero crime rate increased in 2013. Wala namang death penalty noon. So medyo pabago-bago ang crime rate, hindi dependent on the existence of the death penalty or not. In fact, in 2017, the PNP claimed that crime rate was reduced to 9.13%. So bumaba despite the non-existence of the death penalty law. Ngayon, ang aral naman sa mga may death penalty, kasi mahirap dito, walang death penalty, ano pa bang aral ng pagpapatayan natin? Ayun, yung slide pala na tinutukoy ko. So let's go to the next slide na lang kasi I know we're pressed for time. Nagkaroon ng aral sa US between the states with death penalty and the states without death penalty. Pansinin nyo po, ang DPS, yun yung mga states sa US na may death penalty. Yung NDPS, yun yung walang death penalty. In 2012, 4.98 ang kanilang crime rate for every 100,000 population sa may death penalty. Pero tingnan nyo ang sa non-death penalty, 4.09. So mas mababa ang crime rate doon. No? Naulit yan. Consistent yan. Actually, yung data na yan, hindi ko na lang sinama. But it started way back 2007. So, ang 2013, 4.71 ang death penalty states, pero 4.09 lang ang mga non-death penalty states. We go straight na sa 2018. 5.34 ang ang crime rate sa death penalty states, whereas ang non-death penalty states is 4.1. So klaro that it did not deter crimes in the United States. No? There are some states na meron, some states na wala. Yung pinagbago lang pala sa data na yan, dati ang New York sa death penalty siya nakalagay na state, pero later on, na-declare kasi unconstitutional ang death penalty sa New York, kaya nandito na siya sa NDPS. Next slide, please. Now, let's go to, there's a study that says consensus among criminologists that the death penalty does not add a significant deterrent above the long-term imprisonment. Sabihin, death penalty or long-term imprisonment, hindi siya nang-deter. The crime rates almost follow, sabi nila. So, 88.2% of criminologists sa buong mundo, according to the Journal of Criminal Law and Criminology, 88% do not believe that death penalty is a deterrent. Problem, kung hindi pala siya deterrent, do we continue to push through with it? Many of the arguments noong panahon ko dyan sa Kongreso has always been anecdotal. At yan ang problem talaga doon ng mga proponents doon. Anecdotal sila. So kung hindi siya deterrent, yung kwento ng mga kasamahan ko, mga kaibigan ko sa Kongreso, na may bata na pinatay, ni-rape, yung may matanda na binaril, lahat yan pwede pa rin palang mangyari kahit may death penalty. So the entire argument falls. The moment that deterrent is not proved by the proponents. Kasi hindi na ako papasok sa iba pang arguments. You know, yun yung main cause eh. I will not go into the lawyer's talk dito. Some lawyers will argue the Constitution allows it at hindi yan prohibited. Some lawyers will argue, I will side with them, of course, that no, it's unconstitutional, etc. Diba? But I will not go through that. Religion, I will not go through that. I'm not even an expert in that. But some proponents noon cited an eye for an eye. Sabi sa religion, there were also opposition who will say, well, turn the other cheek. Diba? Kung ano yan eh, may dalawang side palagi dyan. Diba? So, merong nagsasabi na it is allowed by various religion, death penalty, but there are some religious positionists naman na nagsasabi, nakalagay naman dyan, thou shalt not kill. So I will not go through there. We go to the deterrent kasi yun ang pinaka-main issue dito. Ulitin ko, we are going to send people to their deaths. The least that we can do is to at least prove na may function itong pagkamatay nila. Kasi kung hindi ma-prove ng proponents na deterrent nga ang death penalty sa crime, at ang masite lang ay anecdotal na, do you think it lowered? Maybe, maybe not. Whereas mayroong statistics showing na hindi siya nag-deter, mahirapan po tayong pumunta doon. Of course, na banggit naman siguro ng ibang speakers, na swift and sure punishment yung issue. I mean, if you're going to go to prison for life, or reclusion perpetua for that matter, at death penalty yung isa, would it really deter you? In fact, most criminals, according to a study that I can cite, they don't think of getting arrested when they commit the crime. So hindi yun yung issue sa kanila. And to think na kung ang justice system, of course, is faulty, then lalong may problema tayo. So I'll end, Mr. Chair, kasi patapos na ang oras natin. There is a death penalty in the Philippines today. In fact, for me, the main argument against President Duterte is that there's death penalty in the Philippines today. Marami at libo-libo na ang namatay na drug suspects. May mga nagnanakaw dati sa snatch ng cellphone, sa Quiapo, patay. But it didn't deter drugs or so many other heinous crimes. So kung hindi pala siya deterrent para sa akin, Mr. Chair, the main reason for the proposal of the imposition of the death penalty law is taken out kasi wala na siyang rason kung hindi naman pala siya makadeter doon sa krimen. So, registered with Mr. Chair ang posisyon ng National Union of People's Lawyers na opposition kami sa pag-pass ng death penalty bill na ito. Maraming salamat po, Mr. Chair.
Thank you. May we now go to karapatan Representative Roneo Jigs Clamor.
Good afternoon, Chair and distinguished members of the House of Representatives. First and foremost, we would like to thank the Committee on Justice for inviting us to share our position on the proposed bill on death penalty. Karapatan, Alliance Philippines, Human Rights Alliance of over 40 organizations in 16 administrative regions in the country, has already submitted our position paper to the Committee on Justice.
Mr. Chair, if I may ask lang, Mr. Chair, for Jigs to Clamor to please, may electric fan siguro sa gilid mo. If I may, Mr. Chair. Hindi ko kasi marinig, Mr. Chair. Thank you.
Okay, thank you, Mayor. Noted for Attorney Colmenares. Okay, may I just mention some of the important arguments because the previous speakers have already expounded on the position why they are opposed to the imposition of death penalty. Allow me to just to cite some of our position in the position paper we have submitted. One, Karapatan notes that in all of the proposal to reinstate the death penalty, not a single credible research or study had been cited or conducted to support the assertions of the bill's authors that said measure will effectively deter the commission of the aforementioned crimes, including drug-related offenses and those related to rebellion or even terrorism. What has been clearly misstated in several studies, research, and surveys is the assertion that capital punishment simply does not effectively deter crimes. That was already mentioned a while ago by Attorney Colmenares. And then we would also like to reinstate that the death penalty will wantonly and deliberately violate international human rights instruments, foremost of which is the International Covenant on Civil and Political Rights. Earlier, there was a discussion whether or not are we duty-bound to adhere in the second optional protocol. On December 6, 2016, former UN Commissioner for Human Rights Said Al-Hussein has written an open letter addressed to the Justice Committee and Senate of the Philippines. And he said that international law does not permit a state that has ratified or acceded to the second optional protocol to denounce it or withdraw from it. Said asserted that there is no denunciation clause in the protocol, thereby guaranteeing the permanent non-reintroduction of the death penalty by states that ratified the protocol. In June this year, UN Commissioner for Human Rights Michelle Bachelet mentioned in her report that proposed bills to restore death penalty would breach the country's obligation under the international humanitarian law. And lastly, with this measure, we think that there is a danger now that political prisoners will be dealt with capital punishment, not to mention that actually majority of them have been slapped with trump-up charges, and actually some of them were wrongfully convicted when they should be released on just and humanitarian grounds. Death penalty in a bankrupt criminal system will not curb nor eliminate crimes in the country only when the underlying causes of crimes are dealt with significant and comprehensive social, economic, and political reforms that uphold people's rights and welfare can crimes be reduced or eliminated. Allow me to take this opportunity, Chair, by extending our gratitude when you did file a resolution in April this year calling for the temporary release of low-risk offenders, elderly and ailing amid this pandemic period. Thank you very much, Chair, and thank you very much to all of you.
Thank you. We go back to is Bishop Marigza around?
Yes po, Your Honor. Good
Okay,
afternoon.
sige po,
Good
go ahead.
Good afternoon po. I represent an ecumenical group while I am the General Secretary of the National Council of Churches in the Philippines. But we are appearing here in behalf of an ecumenical group called One Faith, One Nation, One Voice. We declare our opposition to the capital punishment. The 2nd century Christian martyr, Irenaeus of Lyons, who received a sentence of death from the Roman Empire, once wrote, "The glory of God is a human being fully alive." At the heart of the Christian faith is the belief that each person is loved into being by God, created by no less in God's image, predestined from the beginning to become the image of the Son of God, Jesus Christ himself. There is no higher view of humanity than this, that each human person is given the gift of life to share in the image and likeness of God. An attack on any human person, the image of God, is an attack on God. Moreover, at the core of our proclamation of the good news, the gospel of Christ, is that God's Son came not to condemn, but to offer redemption and forgiveness. The Lord is long-suffering towards us, not willing that anyone should perish, but that all should come to turn to Him, says 2 Peter 3:9. Rather than take the life of sinners, Christ came to offer His own life for our redemption. Such is the depth of God's love for us sinners. At nothing, neither human sin nor injustice nor evil, can separate us from the love of God. This is the faith we confess, and we oppose the death penalty because it is contrary to the Christian principles of respect for human life, mercy, forgiveness, and charity. Furthermore, we also oppose the death penalty on the grounds already mentioned by others, that it is anti-poor, and that in the light of the serious flaw in our judicial system, as even attested and shown through statistics earlier, that death penalty would be wrongly imposed on the innocent and the vulnerable. There are proposals even in the bills that death penalty be imposed on those who are on the opposite side of those who are in power. And this would weaken democracy and silence political opposition by sentencing those who are doing political dissent to death in the name of national security. Then, of course, it has also been shown that capital punishment does not act as deterrent to crime. Our declaration of opposition to capital punishment should not be taken as a statement that persons who commit serious crimes should not be held accountable. In consonance with our Christian faith, we call the government to offer offenders rehabilitation so as to restore them to communion with God and the human community. And in this time of pandemic, we call on our government officials to devote their energies on the betterment of the majority of its citizens who live in poverty. To our president, to our lawmakers, and to our citizens, please heed God's word. I set before you life and death. Choose life. Deuteronomy 30 verse 9. Thank you, Your Honor.
Salamat po. Is the PNP representative still around para matapos na ito? Comsec, wala na. Okay, Comsec, kindly schedule the next hearing, notify the resource persons for their availability for interpellation. Maraming salamat po sa mga resource persons natin, and thank you also to our colleagues. Is there any motion? Meron pa ba?
Your Honor, the
Ah.
PNP is still here, Your Honor. They are just muted.
Okay, so any motion for suspension of the meeting?
Mr. Chairman, I move to suspend the meeting.
I second.
Okay. It having been moved and seconded, the meeting for today is suspended. And again, the resource persons will be advised in writing on the scheduled next hearing and kindly be available for interpellation. Maraming salamat po. Session is suspended.
Thank you, Mr. Chairman.